everyone. Thank you for joining us. If you haven't already, and I can help you with this, I see Wendy has done it, Hans has done it, Philip has done it. Thank you. If you could take a moment to rename yourself to include your firm name, and you can do so by hovering over your video or your name in the participants list and clicking on the three dots from your video or the more from the participants list, and then there's an option to rename. If you haven't figured out how to do that, you can also send me a chat and I can help you with that. But I'm going to go ahead and hand it over to Ryan. Is that correct, Ryan? I think you're leading today's meeting.
Yeah, I think Ryan, me and Philip.
Perfect. So as you saw in sent out this morning, the reminder email, we are doing a round robin today so that everybody has an opportunity to share what is keeping them busy these days. So I'm going to go ahead and hand it over to Ryan and Philip. We may have some latecomers that we'll let in, but Ryan and Philip, go ahead and take it away.
Hello, everybody. This is Ryan Kurtz with Miller Martin in Atlanta. Hope everybody's having a great day. Good to see everybody again. We've changed the format for our meetings a bit to try to keep people on their toes. As before, we were recruiting different firms to do presentations. We've got a round robin format for you today, where we're going to allow. I say allow. We may force people as well, but to speak for a few minutes about what's hot or new or interesting in your particular jurisdiction related to dispute resolution. Following that, if we have time, we'll try to get into some networking. So before we get started, I don't know if Philip and Wendy, if you want to say anything.
Well, I think you have said already what's the plan for today. So we did not try that before. We hope it will work out, and we are really interested to hear from everybody who is participating. As Ryan has said, what is right now kind of hot topic in the area of dispute resolution, and apparently it's more interesting for everybody if it has some relevance also for clients from abroad. So Ryan, I think you might start in case there is anything which is hot in Georgia or in the whole US.
Yeah, so I'll start with a brief update in the U.S. and then I hope that some other participants will jump in. But with respect to the U.S. jurisdiction, there's been a surprising number of ADR related issues that have made their way to the U.S. Supreme Court in recent years, particularly in the area of arbitrations. One of which, unfortunately, wasn't heard. It was ultimately accepted by the Supreme Court, and then the court declined to hear it. But it involved the question of arbitrability and who decides questions of whether an issue is arbitrable. I think historically, that decision of arbitrability has been reserved for the courts, but there's been a shift away from that in recent years, and essentially it's in some of the lower courts have accepted the proposition that the parties should be able to by contract vest the arbitrator with the decision of determining whether a dispute that's come before the arbitrator is subject to arbitration or not. And essentially, the U.S. or some of the lower courts have, I think, fairly consistently held that as long as there is a clear and unmistakable evidence of an agreement by the parties to authorize the arbitrator to make that determination, that the courts are willing to accept that. And so, you know, that's probably a good drafting tip for those practicing either in the U.S. or drafting an arbitration clause that envisions U.S.-based arbitrations. And so, you know, you can now, I think, although again, the issue hasn't been finally resolved by the U.S. Supreme Court, but I think the common understanding now is that you can vest the arbitrator with the authority to determine whether the dispute is arbitrable. Interestingly, a lot of times it's not as explicit as you might expect. Many times that can happen by reference to a particular set of arbitration rules. Many arbitration rules have a particular rule that allows the arbitrator to determine issues of arbitrability. And so if your arbitration clause just simply says, we're going to arbitrate this dispute pursuant to the rules of the American Arbitration Association, for example, because those particular rules have a rule related to arbitrability that vests the arbitrator with the authority to determine issues of arbitrability. The courts typically say, when you adopted those rules or agreed to arbitrate subject to those rules, you vested the arbitrator with the authority to determine issues of arbitrability. Another topic I wanted to briefly touch on, and I may have mentioned this in a prior presentation, but I wanted to dig into it a little bit deeper, and that relates to a provision of our federal code commonly referred to as Section 1782. This is the provision in the U.S. that allows foreign litigants to seek discovery that is based in the U.S. So there's a federal statute that allows litigants in foreign proceedings to seek the aid of the U.S. courts to obtain depositions, documents, and other evidence located in the U.S. for aid in those foreign proceedings. For years, there was a split of authority as to whether parties to a foreign arbitration proceeding could avail themselves of this statute. Some of our circuit courts, our appellate courts, would allow that. Other courts would not. And last year, the U.S. Supreme Court took up the issue and essentially ruled that it doesn't apply to litigants that are parties to foreign arbitral proceedings, that it's typically limited to parties to essentially court proceedings. And this was based on a lengthy discussion of what a quote unquote tribunal is, because that's the word that's referenced in the federal statute. And essentially the U.S. Supreme Court determined that in this context, the word tribunal references a government-sponsored court proceeding. So that tool is no longer available as a general matter. There are some minor exceptions, but as a general matter, that tool is no longer available if you're in a foreign arbitral proceeding. I know Wendy does a lot of arbitration work and is probably familiar with this decision. So with that, I think I will. Those are a couple of the topics that are sort of new and interesting in the ADR world here in the U.S. With that, I think I'll pass the baton and see if anybody else would like to follow this with a short discussion regarding their jurisdiction.
I think we might have to call people out, Ryan.
Hopefully everybody's fully awake. I don't
Let me, yeah, hi everyone. Let me pick this up. So, my name is Rajendra. I'm from AZB and Partners in India. I work out of the Mumbai office, and we recently advised a client, and to some extent, we may also have input from Wendy on this, because while I'm seeing this from an Indian perspective. This comes out of a proceeding in Singapore. So one of our private equity clients, Westbridge Capital, had an investment into a portfolio company. Interestingly, a company that does alliances between individuals. In India, we call it getting married. It's called Shadi. So this was called Shadi.com. And one of the promoters of the portfolio company decided to try and obfuscate our Singapore proceedings, our Singapore CET-based arbitration, by starting a proceeding here in India under our Companies Act, which allows you to go to a special tribunal for operation and mismanagement. And we first got an anti-suit injunction from Singapore, and we got the Singapore High Court to confirm it on the basis that, one, the law of the arbitration agreement would have the same law as the substantive law of the contract, but no, the Singapore court did not agree and said it has to be the law of the seat. And since the seat was Singapore, whether operation mismanagement is arbitrable or not would depend on the law of the seat, which is Singapore. Incidentally, in India, operation and mismanagement cannot be arbitrated. However, in Singapore, it could be arbitrated. The defendant, the original defendant, filed an action before a division bench to the appeal court in Singapore, and the appeal court also upheld the order of the single judge, although on slight different reasoning. The appeal court went into what the law would be, analyzed the language of the arbitration clause, and came to the same conclusion that the anti-suit injunction should be upheld. From an arbitration law perspective, it provides good guidance on what happens in case if an arbitration clause does not have a specific provision for what law would apply to the arbitration agreement. I don't know, Wendy, if you want to add something.
That's fascinating.
Yeah.
I'm curious. How did you get the anti-suit injunction? Was that done on an expedited basis? Yeah.
So that's correct. We filed an application, and we requested the judge who gave us the anti-suit injunction. We gave an opportunity to the other side to immediately come and vacate it. And when the other side came back for vacating it, in true Singapore style, the trial was fixed up in 4 months. The suit was heard within 5.5 months, and a judgment was given to us within 8 months.
Go ahead, Wendy.
Yeah, I think Rajendran's right to say true Singapore style. So I'm quite sure at least on an interim basis, you would have gotten in some sort of relief from the court as well if you applied for it. If you are able to establish urgency, the courts are very quick to give interim relief. You can get something ex parte within the day, even with notice. You could get a hearing very quickly, 1 week, 2 weeks, if you're able to justify the urgency. Just to add to what Rajendran has said about the case, what was interesting that came out of the Court of Appeals decision is that the court clarified that arbitrability will be decided on a two-pronged level. So I think Rajendran mentioned, first, the court will look at the law of the arbitration agreement to decide if the dispute is arbitrable. That's the first test. And if the law of the arbitration agreement, be it India law or any other foreign law, holds that that dispute is not arbitrable, then the matter would not be referred to arbitration. And then there is a second prong, because the seat is in Singapore. So the court says, well, even if you pass that first prong, there is the second test of whether the dispute is arbitrable under the law of the seat in Singapore. So I think after the decision has come out, a lot of corporate lawyers, people have been talking about the case, because there seems to be discussion now as to whether you should specify the law of the arbitration agreement in your contract, because if you don't specify the law of the arbitration agreement, it may not necessarily be the substantive law. I mean, the court chooses between the governing law, the law of the seat, and what they might call the law of the greatest connection to the dispute, right? So I think people have now started to address their minds on, well, maybe it makes sense for us to actually specify the law of the arbitration agreement. Most of us do not actually do that. We only specify the law, the governing law of the contract, but not the law of the arbitration agreement. But now it seems to have an added importance given that the court is saying arbitrability is decided first and foremost by the law of the arbitration agreement, and that does not necessarily have to be the governing law of the contract. It depends on a number of factors that the court will look at, including parties' intention, what was the closest connection to the dispute, and to avoid doubt and to avoid arguments. Something that our corporate colleagues are considering now is whether to specify the law of the arbitration agreement in contracts when the arbitration is going to be seated in Singapore. So I think that's maybe the other interesting point that's come up of the case in terms of practicalities.
And Wendy, I'm sorry, maybe you said this, but in those cases in which you don't specify the law of the arbitration agreement, but you've specified, for example, the law governing the dispute, and you specified the seat of the arbitration, in this case, Singapore, what law would typically be applied to the arbitration agreement? The law of Singapore?
Well, actually, the starting point would be the governing law. So that's the starting point. In this case, I mean, Rajendra will correct me if I'm wrong. I believe the governing law, the substantive law was Indian law, and that was taken by the court to be the law of the arbitration agreement as well. So that's the starting point, but it can be displaced. It can be displaced if, for example, a dispute is not arbitrable under that governing law. The court may say, well, parties may not have, perhaps they didn't choose that to be the law of the arbitration agreement, right? But the starting point is the governing law of the contract.
Okay.
But it's not the be all and the end all.
Right.
That's tend to be the approach of the Singapore courts. They tell you what the starting point is, and then they'll go on and analyze various other factors to decide what the ultimate answer is, fitting the justice of the case. So, which is why it is important actually that this arbitration is seated in Singapore for parties to actually think about the law of the arbitration agreement and whether they want to specify it. So you don't leave it up to the court to decide what the law of the arbitration agreement is going to be.
Excellent. Thank you, Rahendra and Wendy. That's very interesting. Is anybody else prepared to speak, or shall I start threatening with picking people out?
I can, if you want me to, Ryan, I can say something.
Yeah, please, Neil.
Hi, everyone. I'm Neil. I actually work with Ryan. I wasn't prepared for this, but I was actually preparing something else, so I might as well talk about it. There was a big deal for those that have operations in the state of Florida. If anyone does, Governor DeSantis, who most people think is going to be running for president next year anyway, just signed what's known as House Bill 837, which is a massive tort reform bill within the state. So it's going to limit from a liability perspective. I won't go into all the details because I don't know them all yet because I just started reading it. But it limits liability for attorney's fees, limits liability on statute of limitations. It's a pretty big deal, to the point where the largest plaintiffs firm in the country basically threatened all of its lawyers and told them, do not give any courtesies to opposing counsel in any disputes that you have with them. None, zero. And that got put out to the press. But I'm just going to quote one sentence. It will be a serious internal offense if we find any courtesies being extended to the insurance industry. So to the extent that you all have any clients with operations in Florida, it would be good for people to know what the new law says, what the liability limits are now, what the statute of limitations for the big one, statute of limitations for negligence cases went from 4 years to 2 years. So a lot of infighting going on. Governor DeSantis is making a run. Well, hasn't announced yet, but he's been getting a lot of press, both positive and negative, related to this. But it is something to talk about.
Thanks, Neil. That's interesting. I should add, I guess that the hottest of hot topics in the U.S. now is the fact that our former president is being arrested today in New York City. But we'll save
I
that.
thought that might be what you were going to start off with, right?
Oh,
We'll save-
well, there's nothing to say about that yet. The indictment, once the indictment comes out at 2:15, then there'll be a lot to talk about.
Right.
But nobody knows what it says yet.
And what about the Georgia investigation? Like,
Yeah,
should be in
well,
the pipeline as well.
Yeah, a lot of things. There's a lot of speculation that he's going to be indicted here in Georgia in the near future, and some speculate that the charges against him will be, let's say, stronger than those in New York. But apparently, there's a bit of a race to the courthouse, Lewis, to see who can get there first. So we'll save that for our next session. Is it anybody, Lewis, do you have any updates for Canada that you'd like to speak to?
Things are, well, from a litigation standpoint, and I guess it's good news, but things are collapsing these days, and like we're seeing a significant influx of litigation in a number of areas, but infrastructure is one of them. And there's a lot of real estate partnerships which have been ongoing for quite a while. And they all have been, for tax reasons, structured as limited partnerships. And you typically didn't have a lot of cases dealing with what happens in extensive litigations. And probably because of a mix of the structure and the industry, like real estate is being hit pretty hard in Canada. I assume it's the same in the US and maybe not in Europe, but like right now, the mix of interest rates, the occupancy being like very low in commercial, in the office towers area, like there's a lot of real estate partnerships essentially seeing major disputes between the partners. It does bring a number of interesting issues from like our litigation standpoint as to how do you deal with that, and can you just, there's a lot of cases about director duties in corporations context, but how do you apply those in connection with a limited partnership? There's also a corporate remedy in Canada called the oppression remedy. The UK has it, but it's essentially, and probably some other common law jurisdictions would have that. It allows the courts to intervene and essentially remedy corporate wrongs. So whatever significant majority shareholder is using its power to trying to find a more polite term than screw, but essentially impose its will upon the minority shareholders, the court has a right to arbitrate and enforce what is called the reasonable expectations of that party, which may exist notwithstanding the contractual rights. There's a big question here as to whether you could translate those to a setting of limited partnerships when you have highly detailed corporate contracts, which have been thoroughly negotiated by our partners. And the courts so far have stated that reasonable expectations of the limited partners essentially should sit within the four corners of the agreement they've negotiated. And if you fail to negotiate something, that's your problem. And I'm very happy because I'm typically sitting or representing the big guys. But there's a number of cases ongoing where I'm seeing opposing counsel trying to get the oppression remedy applied in a context of a limited partnership. So like it's and like there's an increasing number of cases dealing with that in Canada. It used to be really limited partnerships used to be just a very nice tax driven structure, and partners would be doing that because you would be taxed not at the partnership level, but it's a flow through, so you're taxed like the revenues are essentially taxed directly at the limited partners level. When you are a big institutional shareholder, and Canada has a lot of pension funds who are not being taxed, like it's a perfect structure for them. And they over time have entered into a number of agreements with like operators, where the operator would be the operating partner, would have only a very small chunk of the equity. Most of the equity is going to be in the big pension fund. And like these are exploding one after the other. So that's the news in Canada these days.
That's interesting. So it sounds like the Canadian courts recognize that this oppressive doctrine, or however you refer to it, can be properly limited by contract, which I think makes sense.
Yeah, it's typically a doctrine that has been used. Like if you look at the older UK cases, it would typically be like the first cases that would apply that would be in family partnerships, or like a family business where you have a brother who's been working.
Yeah.
Right. Then there's a dispute. One brother just kicks the other out, and like the court said that the brother had a reasonable expectation that he would remain in the company. And it's been over time mostly used for closely held corporations, but we have seen a use of that increasingly in large publicly traded corporations. And like that's, for us, it's a good tool. Like it does create some uncertainty in the deals, which our partners hate and which we like, but that's the thing.
Excellent. Thank you, Louis. Philip, do you have an update for us from Switzerland?
Yes, of course. I guess that made some headlines also beyond Switzerland. Very recently, we had this crisis of our second largest bank, Credit Suisse.
Yeah, I heard about
which had, it's kind of really disappointing, considering that Credit Suisse did quite well in 2008, 2009, when UBS needed support from the state, which actually was in the meantime paid back and was a good deal for the state. But now that was now Credit Suisse, and it was within basically one week that the bank started to implode, and so it was during a weekend when basically the bank was saved by a transaction organized by the government, so that UBS is taking over Credit Suisse, pays about 3 billion to the shareholders, and that's where the disputes come in. They decided to write down certain bonds, which have a value of about 16 billion. They are called additional tier 1 bonds, and now there is kind of threats of litigation. I'm not aware that already a claim has been filed, whether the writing down of those bonds was valid or not. Of course, the first reaction is, how the hell can it be that kind of debtors, which are not shareholders, that they lose the money completely, while the shareholders, they still get something for their shares. It's not much, it's but still, but it seems that there are certain provisions in those bonds that they can be written down in certain situations, and it's the wording is not very clear, but it refers basically to the situation where the state helps, and in this case here, as there was help by the state in the way that they, on the one hand, they provided a lot of money as a loan, like in the range of 100 billion, was provided as a loan by the state, respectively by the national bank, and yes, and they also kind of under certain conditions they have to make an additional payment to UBS if those if certain assets which could not be assessed within a week if they would turn out to be very bad ones. And yes, now that there are disputes which are being threatened by those bondholders, and so that's certainly now the hot debate here, whether that will prevail or not. And it's also interesting. Basically, my view probably that the claim would have been filed against the Swiss state, because that's basically the one who decided that the financial authorities who decided that this is written down. But on the other hand, of course, taking advantage of that is Credit Suisse and it's by UBS.
Thank you, Philip. That's certainly it's been a lot of publicity and press about the Credit Suisse situation. Also, we've had some recent banking issues in the U.S. as well that have caused quite a lot of issues and I'm sure spawned litigation. That's very interesting. Is any Hans? I saw that you were unmuted at one point. Are you available to give us a brief update?
Sure.
Excellent.
There's a brief update from Sweden. I'm Hans Dahlberg Holga with Zetterwalls law firm. I have a lot of construction disputes, and the construction industry, I think worldwide, has recently suffered a lot from increase of costs for material, and at least for the Swedish contracts, there's sort of a economical force majeure clause, you could say, that has not been used since the 1980s. And everybody forgot about it, but it has been found in the archive, so to speak. So now all the construction companies wants more, get paid more to avoid losses in the projects, and the employers do not want to pay more because they have sort of went into the projects when the prices on the market for the estates was higher. So there's a lot of disputes going on around that clause, basically, and it's the same clause in almost every contract. And it's very difficult to apply due to not thought through requirements in the clause. So that's the one big thing in Sweden. Otherwise, we had a Supreme Court asked questions to the EU Court of Justice on the issue of production of documents, and if you can have a defense that relates to GDPR, the personal data rules in the EU. Do you have to hand out documents if they contain personal data, which is sort of, they always do almost. And the conclusion from the EU Court of Justice was that it doesn't prevent it per se, but you have to look to the purpose of the production of documents and see, and also perhaps you have to anonymize, etc. But it could be a valid defense for a company that does not want to hand out documents in a production request to try to defend with GDPR rules. Apart from that, the SEC in Stockholm is trying heavily to advertise its SEC Express rules, under which you can agree with your opposing party to have sort of a light evaluation of your dispute. So then you can hand it to a neutral sort of arbitrator who will assess the dispute and will have to give a report of findings within 21 days. Sort of you can get a sort of hint of where you will end up in a dispute. So far, they haven't had any case, but they are advertising it heavily, so it must be very good. And that was about it, I think, for a short summary.
That's fantastic. That's really interesting stuff. I mean, I'm particularly interested in this GDPR issue just because in the U.S., you know, your company email is essentially deemed to be property of the company, and as an employee, you have virtually no privacy rights in your company email, and that's sort of a starting point. And then I guess the other issue we have in the U.S. is that we have very, very broad pretrial discovery, and in virtually every commercial case we litigate, we have to produce company documents, and typically, you know, those documents are gathered through electronic processes of using search terms to search across the server, and so you sweep up thousands and thousands of company documents. And I've you know, litigated in the U.S. on behalf of some European companies, and we've looked at these GDPR issues, and it does, you know, we've asserted this defense, you know, in some U.S. courts as well, with mixed results, but it certainly is noteworthy and interesting, just because the reach of the GDPR is so long, and it does impact, you know, European companies as they're involved in litigation outside of Europe, including the U.S. So that's extremely interesting. Thank you for that, Hans. That's fantastic. Is anybody else available to give us a brief discussion from their jurisdiction?
I think Vari has
I think
already
Vari,
raised her hand. Yeah.
Okay.
Hi there. Hi there. This
Hi,
is
Vari.
Wari from Chandler MHM. I just want to give you a brief update on the recent change in the Thai law about dispute resolution. It's the first time I've been practicing for a long time, but this is the first time that the court has some self-discipline regulation issue and take effect early in this year, in January, where they put the time frame for all courts to finalize the cases, be it the Court of Justice or Administrative Court or Constitutional Court. I have experienced that many cases that I handle, it could take, for the first court, it start with the first court where they try to expedite it, that judgment is given within 1 year, and then when it goes to the higher court, it could take like 3 years to, from my experience, 3 years to 6 years. Now they issue a regulation where it specify the time frame for all the courts to stick to. Like they try to shorten the time. For the first court, it would be 6 months, and for the higher court, it could be up to like 1 year. And if it take longer, they have to provide a reason. So this is good news. In the past, our justice is always slow. I hope it will be good news for the foreign investor or whoever doing business in Thailand. So that's the brief update from Thailand. Sawadee.
Thank you, Ori. I'm
Thank
curious what but because of the slowness of your disputes, how do your clients typically react to that? Does that lead towards more agreements to arbitrate matters, or the selection of venue provisions outside of Thailand? Do you have any?
Yes.
Yeah.
If it's like international trade kind of transaction, they would prefer to have an arbitration clause. But for some cases, like sometimes it happens, it's not it's a breach of contract out of, I don't know, external factors. They could not avoid it. Like I'm working on the one case where it has to do with international trade, and it has been before COVID. We filed the statement of claim before COVID. We just got the judgment 2 weeks ago. So now I hope that it will get we will get a result faster. And now I'm hoping in that case I got a favorable judgment, and I think the opposing party would appeal, and this time the appellate court have a time frame to follow, so it would shorten the case proceeding.
Excellent.
Just to add in on
Yeah.
this, I think I've seen the Thai courts becoming very robust in terms of enforcement of arbitral awards as well.
Yes.
I'm handling a case now where, interestingly, the BVI courts refuse enforcement of an award that is governed by Thai law on the basis that it was in breach of Thai public policy. But the Thai courts actually allowed enforcement. So there is going to be another round of appeal in the BVI relying on the Thai court judgment. But I thought that was very interesting because everyone in the team, including the Thai counsel who instructed us for the Singapore part, the Thai counsel was so confident that the Thai court was going to find in their favor. And everyone thought we would certainly lose in the BVI and the Singapore. But surprisingly, the BVI courts held that the award was illegal under Thai law because it awarded compound interest. But the Thai courts upheld the enforcement of the award. So I have actually seen the Thai courts becoming more and more robust, I think consistent with what you're saying.
Yeah, yes. It's like almost like like I said, I have never seen this, that it's self-regulated. In the past, it's like they can do anything they want, they can drag along as long as they want, but now they have the time frame to follow. So it's good news.
Thank you, Ari.
Thank you, Kap.
Wendy, I'm curious, do you have any, I know you've had some great comments and follow up on some of the other panelists. Do you have anything to add in particular with respect to developments in Singapore?
Right. So in addition to the case that we talked about together with Vijendra, with the Court of Appeal clarified what is the approach they would take towards arbitrability of disputes. We are seeing a lot of crypto-related work coming out from the Singapore courts, and I don't know if Joel wishes to add on that. My colleague was on the call as well. It's ranging from issues about whether you can freeze cryptocurrency. I think that's quite well settled now. Whether you can freeze NFTs, how you actually go about processing that. Our firm has actually also been the only Singapore firm involved in every single crypto-related insolvency and restructuring work that has come out in Singapore. So we've seen some news now, quite interestingly, talking about how Singapore has moved from being a crypto hub to a crypto restructuring hub. So you're going to see a lot of interesting decisions coming out. Nothing decided yet. I know there are some as to whether cryptocurrency can be considered money so as to fall within the definition of a debt in our Insolvency Act. So number of issues that the court has had to grapple with. And I think watch this space, we're seeing a lot of it. Beyond what you've already seen coming out of the English courts, they're generally holding, for the time being, that cryptocurrency is property, you're able to enforce it. We're seeing a lot of insolvency work as well in Singapore. People are actually fighting about the asset. And so there are interesting issues as to, well, who held title to the cryptocurrency at the time when the company went bust, right? So was it the company itself, was it the exchange? Who actually owns the cryptocurrency in the wallet? Who owns title to it? So you're going to get a lot of fights about this. People are actually going into the terms and conditions of whether it's the cryptocurrency or the fund that you actually subscribe to. I think this year would be the year that you're going to see a lot of decisions coming out from the Singapore court on this front. So it may be worthwhile for us to update the group at the next session about developments on this front. But that's actually very interesting development on the Singapore front. Joel, is there anything else that you thought might be interesting from Singapore?
Yeah, actually, I just wanted to share that, one of the areas in the dispute resolution space that has been growing in recent years is the investment treaty arbitration piece. So actually, one of the more interesting disputes that has come up in relation to Singapore is actually a Singapore investor sued China under the Singapore-China bilateral investment treaty. And that was a case whereby the tribunal dismissed the investor's claim for lack of jurisdiction. They basically had to do with an investor basically owning a mine and exploration license in China. And then it later got zoned as a national panda park. So basically their mine basically just got taken away. And it is interesting because sort of the argument was just about the wording of the arbitration clause. And there are basically about 40 bilateral investment treaties involving China with similar clauses. One of them being Laos and China. And that's one of the matters which Wendy worked on previously before, where we actually acted successfully for the investor. So there's sort of like a difference in like the jurisprudence that has come up, even though the wording is similar. So I was just sort of like looking through some of the BITs that are involved and as well as the participants today, and actually sort of what is called the first generation Chinese BITs. The countries would be actually Mauritius, Greece, Japan, and Chile. So you never know when something like this might come up if somebody has Chinese sort of investment related kind of dispute. Yeah, and we have sort of like done a fair amount of work on this, and I mean, to be honest, I'm really sort of just talking about this because I recently did a case commentary on the matter. So like Neil, it was just something off the top of my head, which I thought I could just share very quickly. Yeah, thanks.
Joel, thank you. That's great, Joel and Wendy. That's perfect. And that's fine. That's one of the reasons we like to get together, because sometimes we're all working on matters that are I think of interest to the group and great to share. Is there anybody else that we can pick on to participate this morning? Give us a brief update.
Yeah, if I may, very briefly. Hi.
Hi, Yoko.
From Japan. Hi, David. Hi, Ryan. Hi.
Hello.
Hi, everyone. Just in case I see some people that I haven't met before. I'm Yoko Maeda from City of Partners, Tokyo-based law firm. Just briefly from Japan, there is one change in arbitration law that is going to be probably enacted this May or in this year. The change is mostly to update the Arbitration Act in Japan with the recent ancestral model law, the recent version. But in addition to that, the Japanese government is going to establish an English-speaking court to deal with arbitration-related cases, because in Japan the cases need to be presented in Japanese language, including the evidence, the exhibits. So in order to enforce the arbitration award, for example, you have to translate all the arbitration award into English and other relevant documents as well into Japanese. So that is a kind of burdensome procedure, but in order to resolve that, the government is going to establish a new court that consists of at least English reading judge. That not necessarily that means that the judge can speak in English, but that would be a kind of small improvement for the Japanese legal procedure in relation to arbitration.
Basically, for the enforcement of the award, right?
Enforcement and setting aside.
Oh, okay, yeah, okay, got it. Thanks.
Thank you, Yoko. That's interesting. Let's see, we're getting towards the end of our hour. Is anybody else?
Hi, I'm Jilly. I'm based in Mauritius, but I have spent the last 3 months at home in Australia, so I might give you more of an Australian flavor update. Mauritius, there isn't really a whole lot to kind of update you on. But just in terms of trends of litigation in Australia, there's a lot of push from both regulatory side and also private side in sort of climate-based litigation. Greenwashing in particular is a big priority for the company regulator in Australia this year. So they're looking at sort of all the misleading consumer law things and company disclosures. But there's also been a few cases brought last year and ones that are ongoing. So shareholders have brought a claim against a bank. There was a class action brought against the Australian federal government in respect of some foreign bonds that were issued and saying that they didn't disclose climate risk adequately in the bond documents. And there was a really interesting novel case that was brought last year. Well, I think this judgment was handed down last year it was a group of students actually. They brought a novel negligence case against the then Minister for Environment in saying that she had a duty to avoid causing personal injury to Australian children in respect of the decision if they should extend an open cut mine that's based in New South Wales. And at first instance, the judge actually found for the students and said that there was a duty to avoid causing this personal injury. So that was unexpected and very exciting at first instance, but then the full federal court overturned it and said that there wasn't such a duty in existence. But the sort of discussions is that this is probably not the end of this kind of novel litigation, that there'll be further attempts to expand maybe the duty or come up with other kinds of suit claims in the future. So yeah, just seeing a trend of more and more kind of climate-based litigation at the moment in Australia.
Yeah, and that's also a topic which we intend to address at our next meeting, where we have already a few persons who have agreed to line up, but maybe if you want to be part of the panel there to give also the input from a different part of the world, I think that would be interesting if you would be available.
Yeah, sure. Yeah, I'll check my diary, but that sounds great.
Perfect. I'll reach out to you, Julie.
We may have time for one last discussion if we can entice anybody to speak up.
Well, hello everyone. I'm Agita from Soran in Latvian office, and as a brief conclusion, as mostly all of you talked about arbitration, we have in the last months we saw two main changes in arbitration culture in Latvia. Let's say Latvian arbitration for domestic arbitration, the situation is quite particular, as we have more than 70 arbitral institutions, and there are some particularities in the rules, like the arbitrators must be chosen from a closed list of registered arbitrators, and most of the institutions have between 10 to 20 people, so that's not a lot of choice for you, and there are no experts, no witnesses, no document production, and so on for the local proceedings. And we were also one of the few countries in world where there were no set-aside proceedings. And hopefully that's going to change, as the Constitutional Court of Latvia just said that lack of set-aside proceedings is contrary to our constitution, fair trial, and so on. So the government has a year to come up with a solution how to implement the change. That's one thing. Well, the government can screw up pretty badly, as they did it with the last amendments in the arbitral law, but we hope for the best. And also, perhaps to conclude, we had a very interesting case on our table for the past few months. An intra-EU dispute on investment dispute on behalf of a Dutch investor in Latvia, and our bilateral investment treaty is terminated, but there is a large sunset clause. However, since the Acmea judgment, the solutions for the investors is to either it's not enforceable in EU, and Latvian courts have decided that they will not enforce any intra-EU investment arbitral award, stating that's contrary to EU law. So even if you go to the ICSID and obtain a favorable award, you must seek enforcement somewhere in the world, and Latvia has now not many assets somewhere else. So for the investors, it's a choice what to do with the loss of their investment: claim EU law Frankovich damages, perhaps go to ICSID, pay a few $1 million in legal and arbitral fees, and hope to get satisfaction somewhere, sometime. And then we had a really interesting recent amendments in local civil procedure law when establishing a new local first instance court for economic disputes. The Parliament adopted a clause stating that this new court will have jurisdiction to hear intra-EU investment disputes brought by an investor against the state of Latvia. So we just slapped our government with a trigger notice that if they do not change the law, we will bring first ever such claim in Latvia and see what happens, because the judges, not one of the judges have an international law experience or even arbitration experience. So it would be interesting to see how that turns out.
That's fascinating, Agatha. Thank you very much for that. It sounds like there's quite a bit going on in Latvia in the ADR world, and particularly with foreign investors. I think with that, we're about at our time. We're into our hour mark. I think this has been very interesting discussion. I like this new format, and I'm very pleased that we had so many participants today. I think it's useful when we hear from people from different jurisdictions. So thank you very much for participating, everyone. I think with that, I'm not sure if Hannah is still on. I don't know if we have any housekeeping matters. Hannah, are you still around?
I am. Yes, just wanted to note the next meeting is scheduled for June 8th, and I did drop the link in the chat to register for that. You can also find that on our website. And then if you have any articles, I see that Joel shared one with us. If you have any articles you want to share, you can also upload those to the website and tag them to dispute resolution. And I'm happy to share those in the next email that goes out. But
I think, Hannah, if anyone has any interesting ideas for our next sessions, please just drop Philip, Ryan, and I a note on it, because we're always looking out for interesting topics to actually talk about.
Yeah, and I know that we touched on it earlier, and Louis Martin, and there were a couple of others who had sent us emails about talking about ESG related litigation, which is perfect because the month of June for us is WLG Impact Month, and that's our network-wide CSR initiative where all of our firms get involved doing something local. And I think that we have quite a few firms signed up for that already. So it's great timing for us.
Yeah, and also thank you, Hannah, for referring to the date for the next meeting, because Europeans, we tend to get confused by the way how you write the date. So it's June 8th and not in August, and it's at 3
That's right.
p.m. European time, which would then be 9 o'clock in New York. And as has been mentioned, the idea is to do the ESG topic then. So we are very much looking forward to that. And so, yes, also from me, thank you very much for all of you for being so active today.